Hi, everyone. Welcome to this week's edition of Smart Counsel for Lunch. I'm Leah Kofis, and I'm one of the attorneys here at the law firm of Samuel Sayward and Baylor in Dedham, Massachusetts, where we focus our practice in the areas of estate planning, probate, elder law, and estate and trust administration. So this week, I wanted to talk to you about how to give assets to your children, the three different ways that you can include in your estate plan that you can give assets to your children. We hear often from clients, I just want everything to go to my kids, and that's it, right? I just want it to be simple. I want it all to go to my kids. Well, you actually have to pick which method you're going to use to give assets to your children. And there are really three that I'm going to talk about in this week's article that you can read, but I'll give you a preview here. So the first way to give assets to your children is an outright distribution. So that means, provided that your children are over 18, you just say, okay, I give assets to my kids and that's it. They can go invest it. They can go do whatever they want with that inheritance, essentially. There are different pros and cons for that. Of course, the pro is that it's very simple, right? It's the simplest way to do it. The con is that it's available to that child's creditors, including a divorcing spouse, including lawsuits. So, it's simple, but simplicity can come with a cost, right? The second way to give assets to your children is an outright distribution, except you kind of have training wheels on for a little while. So it's an outright distribution at age 25 or whatever age you pick. So before your child reaches age 25, in this example, the trustee of this trust for your child will be able to use those assets for your child's benefit. But once they hit 25, same thing. You just release those assets to the children, whatever is left over in their share, you release to the child, and then they can use it whatever way they want. So it provides a little bit more protection, but not protection for their life. It just provides protection up to age 25 or whatever age you're picking. The third option for distribution is actually holding that child's share in trust for his or her lifetime. So basically, the way that this works is your child can be the trustee of this trust. You could name a third party trustee of this trust. But there's a trustee who distributes assets out to your child for their entire lifetime. Now, the benefit here, there are a few benefits. I won't get into all of them on this video. You can read the article for more, but one big benefit is creditor protection. So you have the ability to protect the inheritance that your child is receiving for their lifetime, so that if they get sued or they have a creditor issue or they get divorced, then you can actually, you have the highest ability to protect those assets in this trust for your child's benefit. Whatever you do, whatever three, which of these three options works for you and works for your children, you want to make sure to really think it through. Because if you're just doing something because it's simple, it might not be the right move. If you're doing something because it's the most complicated, it also might not be the right move for you. So you really want to think this through, and really, having the information and having the knowledge to do this, that's what you want to do. So you want to make sure to talk to your lawyer, your estate planning attorney, and figure out what the best option is for you and for your kids. So with that, I'll let you go. As always, feel free to check in with our website, and with our social media and all of our platforms, and we put out articles every week, every Wednesday. So feel free to check those out if you want to hear more about estate planning, probate, elder law, estate and trust administration. But until next time, take care.